working through some grammar here, can they still enter into agreements for the future sale of the deed, even if their name is not on the deed? All right, so I'm guessing this is something like an heir. Let's say dad passed away, and there's a son who should inherit the property, but the name's not on the deed yet. Can they start going into contract and getting the ball rolling before son's name is actually transferred onto the deed through the probate process? And the short answer is no. So it's a real world answer in that, okay, so theoretically, yes, you could do that. You could find a theoretical purchaser who'd be willing to contract with a unprobated heir, let's call it that. But in the reality, buyers don't want to waste their time. Even investors, they don't want to waste their time with somebody who may not be able to consummate the transaction with them. And until probate is complete, they have no way of knowing if you are the actual heir. That's what probate is for, to prove who has the legal right to sell a property. So they would just be entering into a contract with somebody who might be the heir and the ultimate person who could sell to them. From their point of view, they don't know you, obviously, right? So yeah, you could theoretically find somebody who's willing to do that, but in the real world, anyone who'd be willing to do that would probably want a pretty significant discount or some sort of compensation for that risk that they're bearing, and you would not get full fair market value. I mean, think about it. What are the steps that we're talking about? Even before we get to the deed, entering into a contract, they're entering a contract with somebody who is an potential heir, but who doesn't have legal authority to sell. So that would be a problem. Now, theoretically, as a legal fiction, the moment somebody passes away, in theory, at that moment, even without probate, title to the property, again, theoretically, goes to the heir. However, in the real world, no title company is going to respect that. Title company wants to see that property has gone through the proper steps of probate court. So the bottom line, short real world answer is no. You need to go through probate before you can enter into contracts or even change the deed. Anything short of that, you're either dealing with an unsophisticated buyer who's pretty much making a mistake, or you're just going to end up getting caught up at closing anyway because title will not let it go through. So don't waste everyone's time. Just get probate squared away first before you transact. Right? I'm giving this answer based on my many years of experience as a professional executor and New York probate attorney of well over several hundreds of states. Hope you found this helpful. Take care.